Ready, set. Good evening, everybody. This is Omar Serrato with the Tilted Lawyer podcast. I'm joined by my good friend Lauren Knighty.
What's up?
Who's here. She was waiting patiently for me to finish my one stream with Michael Maricini. And now we're getting ready to talk about some Blake Lively stuff. And I haven't talked about this case in over a month.
It's been a while.
It feels like a lifetime ago, but there's been some incendiary rulings, I guess would be the correct term to put it politely.
I mean, the one last night was pretty bothersome. I feel like it's the most. There was a couple others that we also have links to, but the one that we just came up with last night that I was asking about is the one that had everyone kind of up in arms.
Yeah.
Someone just asked if I'm still in the bathroom. I'm right here, bro. So no, I'm not still in the bathroom.
Well, let me. I'm going to get to the crux of this ruling. I'm just going to read Judge Liman's ruling in real time.
Yeah, go ahead.
And it's the one that basically says that Blake Lively gets to discover the family birthing video of Jamey Heath's wife. And why does she get to do that? This is an outrage. And I agree with you.
The key kind of issue there is that she only ever saw 1 second of the afterbirth video, and she's demanding they produce the entire birthing video before the baby was born. So it's a pretty big difference. But yeah.
So I got the right thing. Yeah, no, I know. And so like I was telling you earlier on the phone, the correct objection, which it appears there was not an objection to that request for production. Mm-hmm. But the correct objection would have been no. I'm not giving you that.
Yeah.
It's not relevant. You tell me what it is that you think you saw, but I'm not giving you access to the entire video because you did not allege that I showed you the entire video.
I think they said some of that in their response to her letter where she's asking for sanctions, but when it came to the motion to compel the omnibus that she was mentioning this stuff, and they did not respond to that with an objection to that particular point. So it was a little too late, I guess.
Because you waive, if you don't object when at the appropriate time, then you waive your objection. Yeah. And so I know that everybody's angry at this ruling, but I don't think that Judge Liman could have not compelled further responses.
I mean, I'm more angry at her for requesting it when this is unnecessary, and also I'm just angry in general at the system that this is allowed to go on. I know that this guy, he has to play by whatever rules we have right now, but I'm just saying this is wrong. Nobody should have to do that.
So let's just pretend for a minute that I'm the judge, right? And this is what's in front of me.
Cool.
I haven't read the entirety of this thing, of the ruling, by the way. I read the last couple of paragraphs because you asked me to read those, and I was doing my thing with Mike. But let's just say that the facts I have in front of me was that there was a request for a production that was not objected to, and that was did not comply with the entire request. And now there's a request to compel further responses to fulfill that request. And I'm the sitting judge, and there was no objection. That objection by law has now been waived. As a judge, I don't believe that I can legally not compel further production.
Right.
If that's the facts. And so then the question becomes, why didn't they object? And you were trying to give me some of the context to that. And I can't for the life of me understand why they would not have objected.
So they were saying that they believed they were only compelled to produce footage responsive to what they were seeking from the Wayfair complaint. So from their dismissed lawsuit. And they believed the only responsive material was what they produced, which was the afterbirth video. So they never thought that these birthing videos, the actual whole home birth, fell within the scope of that to where they didn't think they had to object to that.
Yeah, but that's such a rookie. Look, even if you don't think you should object, or even if you don't think you have to object, you lodge the objection, because if you don't, then you waive it. Yeah. Because because you're assuming
they didn't. So I mean, I guess it went how it went, but that was my interpretation of what I read.
So I can't be upset at Judge Liman on this one, because what could he do about it? That was 100% Capital's fault.
Yeah. No, now, I'm just it's not it's not necessarily the judge, but I'm like extremely bothered by the way that non-parties can be like so easily violated. I feel like in these kinds of situations, especially in like a huge lawsuit with powerful celebrities, like
That's why in a lawsuit like this, you object to every fucking thing.
yeah.
Pardon my language. You object to everything.
Did you say pardon my language? You
I
forget
did.
who you're talking to? I mean, it hasn't been
I'm
that
not
long.
used to doing I haven't been on YouTube for
Okay. I was about to say,
in
I'm
a
gonna
salacious
derail
way
that,
for
but all right. You be careful if you want to.
Okay, so is the thing on screen? It's on the screen. I'm going to read it.
Yeah, it is.
This is Judge Liman's decision. So plaintiff Blake Lively moves to sanction defendant Jamey Heath for failing to produce all video footage related to the birth video that the court purportedly ordered produced on August 27th, 2025. Lively seeks sanctions directing Mr. Heath to produce all video footage depicting the birth video, including but not limited to all versions that show the delivery within 3 days of the court's order. Now, that is an overly broad request that could have been cured with a simple objection.
Yeah.
It's
So that's
frustrating.
the whole issue. Yeah.
So, in order precluding Mr. Heath from offering any evidence, including written or oral testimony on the topic of his showing the birth video or any portion thereof to Miss Lively, I think that's the thing that got denied. He's like, yeah, that's stupid. Heath opposes the motion. So the motion is granted in part and denied in part. And I think they granted one and denied two.
So the the thing where she's asking that they be precluded from offering any sort of evidence or testifying about these things. She's now done this with like 3 different issues, and we have the other 2 things to go over, but one of them was like spoliation of evidence, which I won't get. Who is Blake Lively? Funny, Mike. Funny. Okay. Nothing. This is who is Blake Lively. Yeah. God. That's a can of worms we don't want to open. Anyways, I'm pretty sure he knows who Blake Lively is. Anyways, what was I even saying before I saw that comment? It just totally ruined my train of thought, Mike.
You were going to tell us what spoliation was. What's the definition?
Oh, spoliation. So I'm not going to get into what exactly, because we're going to pull up that document in a little bit, and so we can look at it. But she basically wants them to be precluded from testifying to like any of these messages, and for the jury to assume certain things are fact. And then there was also something with redactions with Melissa Nathan. She asked for the same thing. So this is just one of like 3 of these recent requests.
All right. So, well, let's get through this one. On August 4th, 2025, Lively moved to compel the Wayfarer parties to produce a number of documents. Of particular relevance here, Lively complained that Heath had failed to produce documents responsive to her request regarding her allegation that he had shown her and her assistant a video of his wife giving birth while on the set of the film It Ends With Us. In her complaint, Lively alleges that Mr. Heath approached her and her assistant on set and started playing a video of a fully nude woman with her legs spread apart. Miss Lively thought he was showing her pornography and stopped him. Mr. Heath explained that the video was his wife giving birth. The Wayfarer party's complaint against Lively, meanwhile, asserts the following. Lively continued with an outrageous and knowingly false suggestion that she was shown pornography or naked images of Heath's wife on set. This allegation knowingly and maliciously misrepresents an instance when, in connection with the birthing scene, Heath, at the director's request, attempted to show Lively a video that demonstrated the director's vision of the scene. This video which ultimately was not shown to Lively, even though she stated she'd like to see it later, as she was eating, is by all accounts beautiful. Since Lively wanted to see it later, what she saw was the first image at the start of the video, which shows Heath's wife himself and their baby after his wife gave birth at home, a natural birth or a home birth. Lively therefore maintains that she was shown a video of Heath's wife giving birth, while Heath maintains that he showed Lively only a video of himself, his wife, and their baby.
Interject. I think a lot of people are having unfavorable opinions of her because she describes that, regardless of which of the 2 options here it was, as pornography at any point in time. That's a fucking creepy thing to do, man.
There's a lot of reasons to be upset with Blake Lively, 100% for sure. One of them is because she's carrying on with this, and we're 4 months from trial now, with this ridiculous, with these ridiculous allegations, and then she's trying to discover birth videos from Jamey Heath. I guess trying to like support her claim that she was shown pornography. Like, what are we gonna do with this? Let's say you get the whole video.
Yeah.
Heath said that you saw the afterbirth. You're gonna say that you saw the birth. And so who's correct? I don't know.
I mean, you can't really prove that either way.
I think that she should have been, I would have said that she should show or she should be forced to change her request to only that portion of the video which she saw. And she should be forced to describe it with sufficient particularity so that we could identify specifically what portion of the video she's talking about, because she's not entitled to see the private birth videos of Jamey Heath and his wife.
So basically all she said, and this is actually what they said, there's like, this is not what Miss Lively remembers seeing. Like, okay, well, Miss Lively has a very interesting recollection of a lot of things that we've now seen in different footage that came out last week. You know, the video of her kissing Justin when it wasn't in the script, when she accused him of doing that to her. The video where they like show where he, you know, said the sexy comments where it was clearly not sexual harassment.
This out, Lauren. Yeah, check this out. They could have then objected. Okay, if that's not the way that she remembered it, then I'm not going to give it to her because we're going to use it as impeachment. And then we're going to ask her questions on cross-examination, basically describing what it was that she saw on the video.
Well, it is a little frustrating that they didn't take that approach.
I agree with you.
Yeah.
And having spent so much time away from this case, and this is what I'm coming back to, I'm all the more frustrated. I have no idea whose fault it was, but this was a missed opportunity for cross-examination, and this was an easy discovery objection. I would have just said, no, I'm not giving her that because we're going to use it for impeachment. That's it. At the trial, she could view it while she's being cross-examined after she describes what she recollects from that video, and it's either going to match or it isn't. Because it's impeachment evidence, and therefore I'm not allowing her to discover it and make the court contend with those arguments. Whether those are right or wrong, it's better than not objecting. How about that?
Well, I wonder if she was asked to describe what she saw in her deposition also.
I don't know. How much of the depo has come out yet?
Of hers, very little. We've now seen more of like Steve's, Justin's, Jen Abel's, Melissa Nathan's, all the like background players, like her hairstylist, her makeup artist. Like we've seen those, but we haven't really seen much of hers at all. You know, there was that one time they tried to attach the full transcript of her deposition, and they got struck for that. Which I'm not really sure why they did that. It was clearly not going to work out in their favor, but they did try to get the full transcript out there at some point. But the judge said no to that. He struck that before it was ever like unsealed or anything. So we really haven't seen much of what she said in her deposition at all.
See, this I don't know. I get pissed off. I'm getting pissed off because this could have been handled so differently. I'm just, I don't know who was responsible for the objections to this discovery, but they dropped the fucking ball. If I am lead counsel on this and this was an associate, I would be livid that we're now put in this situation where everybody's outraged, but this is truly the fault of counsel. Look, if they made the objection and they made the arguments, they made some argument, any kind of an argument, and the judge ruled against them, then fine, put that on Liman. But Judge Liman cannot be blamed for this one. This was not his fault. Sure. If I was the sitting judge, I could not have ruled in favor of Jamey Heath in this instance because of the way it went down.
Well, I think my initial reaction last night was just like, how could you like allow that? How could you like give that ruling? Why would you allow something like that? But then you have to like stop and think about it. So I had to go over it again this morning when I had more of a rational, head and think about it and say, okay, well, I understand that even the judges, they're limited to, the confines of the laws and like what they're expected to rule as far as discovery goes. He can't just like go rogue and be like, you know what? Nah, we can't have that. Nah.
Well, I'll tell you what, Alex, what is this? Alex 10 says they were bullied and overworked and drowning in sanctions. Yeah, there's something to be said about that. Like this litigation is exhausting. It's easy to make mistakes when you're overworked. And I have no doubts that attorneys probably mostly on the Wayfarer side are overworked with all of this stupid shit. And that is, guess what? That is a strategy. If you got the bankroll then you can litigate that way and just force them to litigate every stupid little issue like what she's been doing from the inception of this litigation. And it started in January. We are now in November, and we got another 4 months to go. Everybody's just zonkered. Zonkered?
Zonkered.
Is that a word?
No, but it is
they're
now.
zipped. They're zottled. They're tired, man. They're exhausted. They're exhausted.
Yeah.
And so somebody has a super comment, and I don't know how to show it. I don't know why my screen is like this.
Just what is your screen look? Yeah, there you go. You got it.
There we go. That one's for you.
Little girl attorney made a great point in a recent tech talk. Jamey / Natasha, his wife, should write asking for in-camera all protections, etc. If Blake declines, her side will look even worse.
100%. I mean, that's a move. I mean, look, I'll show whatever you want, but I don't want to produce it in the normal course of discovery. Let's have an in-camera session.
Yeah,
I 100% agree with that. Whoever little girl attorney is, I agree with her.
We talked about her when we were at lunch.
She sounds familiar.
You saw a video of hers, and I was like, "That's my friend."
Oh yeah, the one you had a crush on,
dude.
Oh, my bad.
No. Why would you say something like that?
Did I get? No, never mind then.
That was not the same person. I'm sorry,
okay,
guys.
My bad.
But now I can't even correct you because then it's like, no, I have a crush on. No, I can't say that either. So no, dude. I do know what you're talking about though.
Well, now I don't remember anything that we talked about. Now I feel like my memory is jaded. I can't trust my memory anymore. I'm remembering things incorrectly.
It's fine. We had some drinks that day.
Yes, we did.
I'm not gonna worry about it.
Oh,
dude, look what you did. Now everybody's gonna. Oh my god, you're such a fucking dick. I can't stand you. I can't stand you.
Well, never mind me. You didn't. It was, I don't. Maybe it was the waitress. Maybe that's who you were talking about.
No, I got half a mind to try to convince everyone I got a crush on Elsrich. just to flex.
All right.
Anyways, moving on, guys. This is not the point of this. Not the point of this little get together.
Okay. So, all documents and communications concerning your allegation in paragraph 101 of the Wayfair SDNY complaint that Miss Lively falsely suggested that she was shown pornography and naked images of Heath's wife on set. Heath did not oppose the motion to compel responses to these requests, and by order of August 27th, the court granted Lively's motion as unopposed. Dude, what the
help? What are you thinking here?
I'm just getting upset all over again because the judge is once again reiterating that Heath did not oppose the motion to compel. So the current dispute is whether the court's order granting the motion to compel required production not only of the post-birth video Heath claims he showed Lively, but also of footage which might support Lively's claim that she was shown a video of Heath's wife giving birth. Because the court's order encompassed more than the video Heath claims he showed Lively. The additional footage should have been produced. And Heath's assumption that was not the case is never going to fly in this situation. The local civil rules for the Southern District of New York establish a certain uniform definitions governing discovery requests. Among the defined terms is concerning, which means relating to, referring to, describing, evidencing, or constituting. Thus, Lively's request for all documents and communications concerning your... This is how stupid discovery gets. They get real literal with these stupid words. It's so exhausting. Like the most expensive thing you do in litigation is discovery. So if there's going to be mistakes made, 100%, it's going to be mostly during discovery. I can tell you this, most cases are won and lost during the discovery process, not on the merits of the evidence, but because of mistakes that are made during discovery. It is a big deal that they did not oppose the motion to compel. It's a big deal that they failed to initially object to that request for production because there's consequences to it. And we're going to see what those are shortly. So I'm going to skip down a little bit because they're just going on about more language. The Wayfair parties argue that Heath does not dispute that he showed Lively a post-birth video and that the question of what Lively saw will not be resolved by production of all footage. that may or may not be true, but that might have been a reason for objection, wouldn't it? However, Heath does dispute that Lively was shown a video of his wife giving birth, and the time for Heath to have objected to producing all footage related to that issue was when Lively made her motion to compel, not after he was deposed and was forced to admit the existence of videos. Thus, while it may be undisputed at this point that footage exists that resembles what Lively claims she saw, the question for present purposes is not whether producing the footage will decisively resolve exactly what she saw. Rather, the only question now before the court is whether it has already ordered production of the footage based on Heath's non-opposition. It has. The materials at issue are no doubt extremely sensitive and deeply personal. They therefore fall within the category of materials in litigation that, while potentially discoverable, are still subject to strict confidentiality provisions preventing public disclosure. The materials are subject to the protective order in this case, and given their sensitivity, it is highly unlikely that their disclosure could ever be warranted. In addition to compelling production of the footage, Lively seeks to preclude Heath from offering evidence on the topic of his showing the birth video or any portion thereof. To her, that request is stupid. Federal Rule of Civil Procedure 37B provides that if a party fails to obey an order to provide or permit discovery, the court where the action is pending may issue further just orders prohibiting the disobedient party from supporting or opposing designated claims or defenses, blah, blah, blah. Court has wide discretion and stuff. All right, these factors counsel against well, I should probably read that, huh? Federal Rule of Civil Procedure 37B2A2, a district court has wide discretion in sanctioning litigants appearing before it. Among the factors a court is to consider is in imposing sanctions under 37B2 are the willfulness of the non-compliant party or the reason for non-compliance, the efficacy of lesser sanctions, the duration of the period of non-compliance, and whether the non-compliant party had been warned of the consequences of non-compliance. These factors counsel against the relief Lively seeks. First, Heath argues that his failure to provide the footage was not willful because the best reading of the court's order was that he was only required to turn over the post-birth video described in the Wayfair complaints. As already explained, the court disagrees with Heath regarding his reading of the prior order. Heath lodged no objection to producing all documents concerning the allegation that Lively falsely claimed to have been shown nude images of Heath's wife, and those documents included one that not only supported Heath's allegations, but also any that might have supported Lively's. The court cannot say, however, that Heath's interpretation was so mistaken or unreasonable as to give rise to an inference of willfulness. Second, Heath has not been warned of the consequences of noncompliance. Third, and perhaps most important, lesser sanctions, namely production of the footage and payment of Lively's attorney fees incurred in making this motion are sufficient. Motion, therefore, is granted in part, denied in part. Done.
So I was a little confused about whether or not she was actually granted fees on that.
Yes, she was.
She was. Okay.
Yeah.
Yeah. Okay. Because it was a little, it felt ambiguous to me. I don't know why. I think it was just because it wasn't like clearly outlined in the last sentence.
Yeah. No, but it's pretty clear. He's going to pay her attorney fees and produce the footage, and there's no reason to go further than that.
Yeah. So that was one of like 3, I think, motions we have. What did I send you?
Hey, you got some super chats here. You should read them.
Oh yeah. Justin Smotherman, thank you for the $2. Louis let her sit with the video for months after discovery close. So she had, I guess, like discovery closed. They had produced that video and she had it for a long time, I guess is what they're trying to say. And then she randomly at some point decided that's not what she remembers.
Hey, my camera's being all wonky. I'm going to shut it off.
Yeah. Holy shit. What happened?
I don't know.
There?
I don't know what's going on.
Yeah.
I need better internet, maybe. Here's another super chat for you.
Thank you, Justin. Why didn't she compel back in summer? I don't know.
We did. Didn't she file the motion in August?
She did the omnibus motion to compel. Yeah, and then so people were looking at these motions for sanctions as like thinly veiled, motions to compel past discovery deadline. You know what I mean?
Yeah.
But yeah, is that mine too?
That one is yours.
Or is that yours? Okay. Super Sarah, thank you for the $5. Isn't the video technically Natasha's and not Jamey's to give? And what about her HIPAA? Can she, as a non-party, object/appeal now? I don't know about the objection appeal thing or the personal property of the video. As far as HIPAA goes, you're only bound by HIPAA if you're like a medical provider or somebody who's working with patients in insurance, like patient information. Random members of the public are not bound by HIPAA, so it's not really a HIPAA violation. So
I don't know if it is or not. I didn't pay attention to the question or your answer. And
they were asking if this is a HIPAA violation to show her home birth, basically.
No, it's not a medical. It's not a. No, it is not.
Well, it's not between patient and provider or insurance, carrier or whatever. So
it's a home video. It's a family home video.
Right. Yeah.
Not within the confines of HIPAA.
Yeah. Yeah.
What else did you want to go over, young lady? 34 years old.
At 33, bro. God damn it.
You are old as Jesus.
I look like him too.
It was the year of his crucifixion.
Yeah. Go to the 2 down. So not the Melissa Nathan one, but the spoliation one. I want to look at that.
Melissa Nathan sanctions? Oh,
Below
spoliation.
That. Yes.
Spoliation.
Okay. Spoliation. Yes. Is it spoliation or spoliation? I get confused. Let's
sound it out. Spoliation.
I think it should be spoliation, but I always hear spoliation.
Spoliation. It's spoliation in the South.
Well, whatever it is, we should open that.
Okay. Is it properly shared?
No wonder your face is glitching. God.
Yeah. You could have told me my face was glitching this whole time.
Oh, I did. It wasn't until like right before you turned your camera off.
Well.
Yeah.
Anyway, that's is it up on screen yet?
Yes, it is.
I will let you read this.
Oh my fucking okay. Well, it's a little harder because you got control of the scrolling. Hang on.
I do that when you control the scrolling all the time. Are you going to do it on your own thing?
Yeah, take your thing off. I'll share mine.
All right. Take your thing off.
Because I'm going to skip lots of stuff. All right.
Oh, I thought your face was like that, Omar. Sometimes my face is like that when I'm trying to interpret how Lauren pronounces words.
Wait, man, which words? All right. I think I have it. Yeah, I have it up here. You just have to share the screen thingy.
Oh, you have it. There you go.
Yeah, there you go. All right. It should be big enough for everyone to read, but I'll probably back out a little bit. So, okay. So they're talking about this untraceable retaliatory campaign, texting and emailing each other, Justin and the Wayfair parties. Their defense from the outset has been that they never moved beyond the scenario planning stage, which was a blueprint intended to bury Miss Lively in her career. As we know, they did not actually go with the full capabilities of the crisis social media team or our PR team or whatever. They opted for the monitoring type services, so that this point is still kind of stupid to me, but whatever. They routinely taunted that Miss Lively will not be able to prove that defendants actually implemented the retaliatory campaign, insisting that the sudden onslaught of negative publicity against her beginning in August 2024 was organic, coinciding perfectly with their plans by sheer luck. Okay, again, I there's nothing that's ever been shown to prove this point. The things that we've seen that came out in the motion for summary judgment and all that, it's all like standard Hollywood PR, defensive PR for your client. It's not like a crazy untraceable smear campaign, but whatever.
All right.
I don't want to read this word for word. I'm just going to go over the important parts that I remember.
Well, you are the narrator, so you do what you want.
It's never a good idea. Defendants have hid the ball at every turn in the discovery process, either failing to produce documents or improperly cloaking them in the attorney-client privilege. I don't know if that's true. Okay. Forcing no less than 12 discovery-related motions to date against defendants and their aligned third parties.
Lauren, you're going to be interrupted because somebody just submitted a $50 super chat,
cool,
and they win. This is off topic. Landshark 911. This is off topic, but if Andy loses his fight against his subpoena in Florida, Can any info from him even be included in this lawsuit at this point, since discovery is closed? Yes, because it's within the deadline, and so it kind of trails. If it's relevant to the underlying causes, then yes, it can potentially.
I mean, they can try to frame it that way, but I know Andy pretty well, and I participated in his documentary, and she's not going to find anything that's going to help her case. Basically, worst comes to worst, and she gets everything she's asking for, like all the information about who participated in his documentary, their communications, and stuff like that. She's going to see that he reached out to people on both sides of the lawsuit to participate, because of course he did. He wanted, to get both sides of the story if he could. He got some crew members who fell more on the side of Justin, who talked to him and shared their stories. I haven't seen the footage, so I can't really tell you too much about it, but I know that much. She wants to go scorched earth and like see everything that was said by anyone who was involved. And it's just like super crazy. She thinks it's going to like uncover some sort of crazy conspiracy. And I'm like, dude, at this point, this is just this ongoing, thing with the subpoena is just to kind of bog him down. I feel like, because his documentary was supposed to come out months ago and he had to postpone it because of this subpoena. And if she really wanted to see that footage, she could have just let the documentary come out.
Well, I'll tell you what. I also know Andy, not as well as you, but I saw him in Arizona. We were at that thing. I saw you participating in the documentary, and
right.
I'll tell you what. I don't think there's anything relevant that they're going to find. So, if they found something relevant, conceivably, could it be used in the trial? Yeah, it can. I just don't think they're going to. I think the reason why Andy is still dealing with this is 100% because of the documentary that he made. And they're trying to keep that out for as long as they possibly can. And if they could keep it delayed from coming out till, say, before the trial, then I guess they win on the PR front, for that matter anyway. I hope that answers your question.
Well, I just figured maybe just on the off chance that the footage did get turned over to Blake, I would leave her a little sign,
Oh, well... well, I thought you already left a bunch of Easter eggs in your texts to Andy.
Oh, they're not Easter egg. I just said, "Your Honor, Blake is a cunt." In our group text. So I was like, okay, fine. If you want to see my text messages, here they are. Your Honor, Blake's a cunt.
Well, she can look forward to reading that. How about that?
Yeah. Man,
right.
Poor
you should
Andy.
Continue with the
poor Andy dealing with me for months.
I haven't talked to Andy in a long time, man. I gotta catch up with that guy.
Yeah, dude, you should.
All right, continue with the spoliation document.
Okay. Well, let me see. I don't want to I've read all this to people already, so I don't want to go through too much of it. But they're saying, despite defendants' clumsy efforts to cover their tracks, there is substantial evidence that the retaliatory campaign was in fact implemented as planned. Okay, there's nothing to support this. There's nothing to support that. Defendants flouted this court's orders and destroyed and or failed to preserve or produce additional material and highly relevant evidence, the absence of which they intended to try to unjustly exploit in their favor. So there's like one main point, I guess, that I want to talk about here. So do you know the app Signal?
No.
Okay. Well, Signal is an app that it's like really secure. Some government agencies have used it. People use it for privacy reasons. It protects your messages, and it auto deletes them after a certain amount of time, as long as you have that setting turned on, which is something that a lot of people, want to do. Lots of people use it for their businesses, especially people in like PR and related fields. And so they have been using this app for a long time, and their messages from Signal were subpoenaed in this lawsuit. They didn't find anything in their messages from like a relevant time period. So now she's trying to say that they destroyed evidence
I got it. That's
by failing to turn off the auto delete function. But the thing is, the way she's trying to frame it is, when she sent that 17-point list of demands to basically, exploit or like, I don't know if extort is the word, I guess, in like a layperson language, extort, them into giving her control of the film. She's now trying to claim that that was a legitimate demand for preservation. But
no, it was not.
But right, exactly. But Michael Gottlieb, in a way more recent filing, since that time, said that her initial demand for preservation was much, much later than that. So she's trying to say in this motion, though, that they were supposed to preserve their messages from November 2023. November 2023, when filming was still happening and all that. There was no lawsuit. There was no threat of a lawsuit.
Yeah.
There was just that 17-point return to production demands document.
Was there any specific language that, hey,
yeah, I'm trying to find
you
it
need to
here.
preserve whatever because this might end up in litigation?
Yeah. So the statement that they used was like not at all by most attorneys that I've heard from, not at all.
By the way, Cassidy O'Connell is already on the finale for Murdaugh. We're like doing our whole review series. We're on episode 2, young lady.
How many episodes are there?
There's like 8. And she's already on the finale. I'm on episode 2. I think we're going to do episode 2 recap on Thursday. Yeah. Anyway, I didn't mean to throw you off.
Oh, no, you're good. I have to look for this. So.
Well, that's very helpful. No, look, a notice like that or spoilation, there's usually a very explicit please preserve all emails and communications and videos, productions, whatever information created on whatever, because of, we're threatening to do such and such at such and such time or in the future or whatever. That 23rd, that June, whenever it was, 2023 17-point letter was not the equivalent of that because they were handling it in-house. They were necessarily outside of litigation. They were they were basically practicing at best administrative law by administrating the laws or the rules of HR upon the production of the film. Had nothing to do with pending litigation.
Yeah.
And so it's a stretch to say that because they had an auto function on this app called Signal that I've never heard about, because they didn't turn off the auto delete feature, that's somehow spoilation of evidence. Kiss my ass with that one.
Yeah. So even since this filing of this action, defendants have continued to use Signal. And as for Mr. Wallace, voice memos. Jed Wallace was dismissed from this lawsuit again, by the way.
Twice.
I don't know if you saw that. Yeah. So after her amended complaint, he was again dismissed. Let's see. I gotta find this language because it's a very specific paragraph that I want you to read because, like, the lawyers that I've seen who read it were like, "What the fuck?"
Well, there's a lot of that going around in this case.
Yeah, I know. If you want to read some comments or something while I find it.
Oh well, just give me the Signal next time.
I'll interrupt you when I find it.
People want to know how Nate the lawyer is doing.
Oh, I don't know. I saw that though, because I've never met Nate.
I've never met him either, but. How does
I know he helped Andy a lot.
Yeah, I saw him on Andy's show once. That's where I know him from. I have no other knowledge of Nate other than that, and he's got a big YouTube channel.
Yeah.
He never ends up on my algorithm. Cassidy is laughing at something. She's laughing at you, obviously. Nate is going in for surgery tomorrow. I don't know on what.
Brain tumor. Yeah.
Oh, really?
Yeah.
Oh, that's a serious one. No, don't I just feel like the...
It looked like it was pretty... I saw, he had posted, I guess, imaging results somewhere on Twitter. I don't know if I actually saw the real one or not, but it looked like it was pretty big.
Well, you know what? While you're doing that, I got to do something that I've been wanting to do.
Yeah.
And I'm in a silly enough mood that I'm going to do it.
Okay.
But now I'm looking for it on the internet. I think I found it. So there was a time.
Are you? Okay, good.
Oh no, I'm not going to play. No. Okay, you remember when we were doing karaoke?
Yeah.
Did I show you the video where that song came from that I was singing?
No. Not that I remember, but that doesn't mean you didn't. I mean,
no, it was I don't know. Is it gonna? It cannot be copyright strike. What do you think? Should I do it or should I not?
If it's a song, it probably will copyright strike.
But it's a karaoke. It's like Shaq rapping.
I know, but it's still so stupid. Like YouTube copyright gets so stupid.
Well, there's this song that after Shaq won the title with the Heat, after he was traded from the Lakers to the Heat, he wins the title with Dwayne Wade. And then Shaq goes out there and he does this rap in front of everybody post winning the championship. Last
you can
week,
rap it for us.
Kobe couldn't do without me. Hey, Kobe, tell me how my ass tastes. And so we were doing karaoke, you and
Suddenly I remember the song.
Yep. And then I just kept on. We were drinking like really poor quality beer because that's what was available.
Yeah.
And I kept singing, David Gingras, tell me how my ass tastes. And we were having a really good time. And it made me think of that.
Yeah. Oh my God.
We had a good time in San Francisco.
Yeah, that was messy. Oh God. I had to work the next day.
Well, I did not. I was specifically off next day.
Oh yeah.
I mean, I was traveling, but still.
Anyways, if you're done, I mean, you can, go ahead and sing the whole thing for us if you want. Otherwise,
no, that's as much as I remember. That's
okay.
the only. Well, do your thing.
So here, paragraph or this number 2 here. It is well settled that a duty to preserve is triggered when a party receives a demand letter. Okay. Here, based on the service of the protections document, which was that November 2023 document, Wayfair, etc., and their principals had a duty to preserve beginning on November 9th, 2023. As explained in the transmittal email issued by Ms. Lively's counsel, the protections document outlined a list of protections that will need to be guaranteed and observed by the film's producers. One such protection included prohibiting retaliation of any kind, including during publicity and promotional work. Further, Ms. Lively's counsel included a customary warning that if the production is unwilling to accept or uphold these protections, and then this is the phrase that they're saying was the demand for preservation, our client is prepared to pursue her full legal rights and remedies. Well, there can be no dispute that this letter put Wayfair, it ends with us, their principals, and Ms. Abel on notice of Ms. Lively's forthcoming suit.
So what does the case law say then? What constitutes a demand letter such that a trigger of a prevention against spoliation is triggered?
I mean, that's you tell me.
Well, why would I know that off the top of my head? I mean, that's going to be the response.
Right.
But I mean, what they're saying is by them saying, by this last sentence, our client is prepared to pursue her full legal rights and remedies. But it's in the course of an administrative HR hearing, essentially, that, look, we demand further protections.
So it wasn't, remember, she was very specific that it wasn't an HR thing because she didn't want to go through official channels.
Yeah, but it was an HR thing. And not technically because she didn't go through HR channels, but it amounts to an HR thing because it was distributed amongst all of the employees and they had a production meeting about it. It wasn't anywhere.
Oh, no, it wasn't. It wasn't distributed amongst all the employees. It was just those couple of people that they wanted to extort. Basically.
Well, then I am remembering this wrong, and I probably
so. This was like when they had that meeting in her apartment where Ryan like reamed out Justin and.
Oh well, the way that I pictured that meeting going, the way that I pictured that in my mind, and it's been a while, was that they were all sitting around in a circle, the production team and all the relevant people were there that were in charge of the protections. Right. So
it was not it was not a big meeting at all. This was just between her and like Justin, Jamey, and like maybe a couple producers. I'm not sure, but yeah.
But so what was the forwarding of that letter limited to the people that were there at the meeting?
I believe so, yes.
Okay. Yeah. And was there anybody else that would have been relevant to having control over the protections over the production of the film that was not at that meeting?
I'm not sure, to be honest. I don't want to answer that question because I'm not sure.
So I guess that's the question then. So how could you say it constitutes a demand letter when it was like this kind of informal, quasi-formal meeting where we were talking about additional protections and you're reading this letter and we're talking about how to better protect people and we're agreeing to protect people. And it was conditioned that if you're not going to protect us, then we're going to pursue all rights and remedies. But the entire meeting was fashioned around employing these additional protections to make sure everybody felt safe. Therefore, there was a mutual understanding that there would not be further remedies or rights needed to be exercised. I guess the framework of what a demand letter is relevant. And I think that discussion needs to be had. Has there been a response to this?
I believe so, but I'm not positive. I believe so, though.
Okay.
I can't remember when, because it's been a little bit now.
So I get the argument they're trying to make.
Yeah.
And they would be right if what constitutes a demand letter is any insinuation that the person providing the letter will pursue full legal rights and remedies if something isn't done.
Mm-hmm.
If that's the definition of a demand letter, then they fulfilled that. But
right.
And they're stating that there was a sentence in there talking about preservation of stuff.
Yeah.
Well, then it's not a dead argument. It's not the worst argument I've ever heard.
So what I've been hearing from a lot of other lawyers, which is not actually Golden was one of them. I don't know if you ever heard of her.
Yeah, I from TikTok. That's
great.
I do
not
remember
gonna,
her.
You're not going to try to like tell people I have a crush on her, are you?
You've never told me that.
Nope, that's nothing. And it was no. She said like that this was almost embarrassing because this phrase is like something she uses or sees or uses a bunch of fucking times all the time in her practice, and like it's embarrassing that they would try to pass this off as like an actual preservation demand.
I guess they'd have to show me a case where it says that the mere mention of future remedies constitutes a demand letter that triggers spoliation as a thing, which I don't know that to be the case, but if they could find a case that says that, then good for them. I've never seen it.
Mm-hmm. But then there's also that issue that Gottlieb said in that her initial preservation notice came in December 2024.
Oh, well, that I'm not.
And that's on the record. That's on the record because they've said that. So
there was a subsequent preservation letter that.
Well, they said the language they used was initial preservation notice.
All right.
In December 2024.
Is it a dispute whether or not it was the initial preservation notice? Of course it is, because they're talking about they sent one back in 2023.
Oh, they are now, but yeah.
So it's, even if Linda says it's dead litigation, it might be dead, but it's still annoying. And you could see why these attorneys. You all right?
Yeah, I've been sneezing
over there.
Oh man, at least it's not the hiccups.
You could see why these attorneys get overworked and just exhausted with this stupid shit. Like, was it the first preservation letter? Was it back in 2023? Spoliation, spoil this, man. How about just this argument is stupid? How about you don't want to do it? Tired of this shit. I get it.
Yeah. All right. Well, so that's all I really wanted to look at there. And there's like one more very short thing. I sent you an email with it. It's the new one. The email with just the one link in it, if you can pull that up.
So Lynn's is adding more context. The December 24 preservation notice is massive from Gottlieb and common for a hold notice. Yeah. So I'm going to go out on a limb and say that the more massive notice is probably the correct one.
Sure.
And I could understand why people would scoff at the 2023 purported preservation notice. Well, but I've also not read the full legal arguments, and so
well, there was also just in the context of everything that's happened in the last couple of months, there was also the impression amongst a lot of people that she didn't really find anything in discovery to support her, smear campaign accusations. Yeah. So now she's trying to go with this Hail Mary of, well, the messages that prove the smear campaign were in November 2023 or whatever. But the thing is, like, they were still in production in November 2023. There was no war in PR or anything like that. They wanted to promote the movie with like friendly intentions to like make sure the film was successful. You can hear Justin talking about Blake in the press even after they had all these conflicts, and he's like very complimentary of her, very positive. And so there was no PR war at that time. So it doesn't really make any sense to me that they would have, thought this went back to November 2023 and there'd be any evidence of a smear campaign at that point. Sure. Because there was no real issue. They signed the document, the 17-point document. They gave her what she wanted, everything that she wanted. There was no reason for there to be a PR war at that point. So
that is just that is just shitty litigating. Hey, there's this app. It's called what did you say it was? Spotlight or something?
Spotlight?
What's the name of the app that disappears stuff?
Signal.
Signal. Yeah. So there's this app, Signal. It's got this self-destruct feature.
It's not like immediate, by the way. It's like after a set period of like
that's what I mean.
Weeks or something.
Let's just make an argument that the fact that they failed to turn off the auto delete feature, let's just call that spoliation and make them litigate it. We're probably wrong, but hell, make them make the arguments.
Yeah.
That's how so much of civil litigation is done. It's exhausting, and so I get why mistakes are being made in this case. It's annoying and it's stupid, and it lacks common sense for the layperson about why we would be arguing about such a thing. But if you read into the rules, it makes all the sense in the world if you're trying to play litigation like they're doing it, which is to exhaust them and throw every single thing at them to make them defend against it. Even if it's a losing argument, they're still using resources to defend against it, and we're scoring some kind of a points, if only for litigation fatigue. Anyway, what was the last thing you wanted to read?
So the second email I sent you where there's just one link in it.
Oh, right.
Yeah.
All right, I got it. Liner, Friedman. All right.
Yeah.
This is
So Blake and Ryan Reynolds tried to supplement that Rule 11 sanctions motion, and I didn't totally understand it, but admittedly I didn't take the time to read word for word the whole thing because I had a lot of other stuff to cover that night. But this is just a 3-page response to it. I guess they're saying no to that for whatever reason. So
well, let's see. What do we got here? So, dear Judge, on behalf of Wayfarer, Justin Baldoni, Jamey Heath, it ends with us, all the people. We write in response to the letter filed by Blake Lively on November 14th, seeking leave to supplement the Rule 11 motions filed by Lively and Ryan Reynolds on May 2025. On May 19th to 20th, 2025, Lively and Reynolds filed Rule 11 motions arguing that the Wayfarer party's first amended complaint lacked factual allegations sufficient to support their claims and were therefore legally unreasonable and factually baseless. At the time the Rule 11 motions were filed, the court had not decided the motions to dismiss, which were based on the same pleading deficiencies cited as grounds for Rule 11 sanctions. In opposition, the Wayfarer parties argued that Rule 11 is not a proper vehicle to challenge pleading deficiencies that were already pending before the court in the motions to dismiss. I remember this. The Rule 11 motions were fully briefed by June 10th when Lively and Reynolds filed their reply briefs. Lively and Reynolds now seek to supplement their Rule 11 motions with excerpts from the depositions of Steve Starowitz and Jennifer Abel, claiming their testimony demonstrates that Wayfarer counsel's knowledge that their clients could not articulate any basis to assert the alleged claims or the challenge claims. The motion for leave to supplement should be denied for several reasons. First, as noted, Rule 11 motions were fully briefed based on the notice provided. Before imposing any sanction under Rule 11, a district court must adhere to the procedural rules which safeguard due process rights. All right. Chief among these rules is 11C2, which requires the party seeking sanctions to describe the specific conduct that allegedly violated Rule 11B in its moving papers and give the offending parties 21 days before filing the motion to withdraw the challenged paper, claim, defense, contention, or denial. They're talking about the safe harbor stuff. Only conduct explicitly referred to in the instrument providing notice is sanctionable.
What does that mean?
It just means that they had a 21-day safe harbor period from the date that this was filed back in May. And now they're trying to add extra stuff after the safe harbor thing has been dealt with. And that's kind of bullshit. We're out of bounds with that. They're making additional arguments on a fully briefed issue after the fact, and it's procedurally deficient.
Yeah, this. Okay, so the timing of this came after the motion for summary judgment dropped, and there was a lot of unfavorable evidence towards them, and then they came out with this. So they're not this, but this is the response. But they're supplement to the Rule 11 sanctions. So it was very much PR driven. It felt like so.
So they're going on. The Abel and Sarowitz depositions were not recently discovered evidence, as their depositions were taken on September 26th and October 3rd, respectively. Lively offers no explanation for filing her letter at this juncture, just days after the Wayfarer party's summary judgment motion. In other words, they're doing this to be dicks in retaliation.
Well, they also
Lively's,
do it like they'll drop this like close to the weekend, so where like nothing else can happen. So this will be the news cycle for however many days, and this actually didn't work this time. Not too many people picked it up because there was so much other stuff going around. But yeah.
Lively's reliance on Sarowitz and Abel's answers to deposition questions about the basis for their legal claims, coupled with the letter's odd timing, reflects an apparent effort to reassert control over the news media cycle. Third, whether a client can articulate the basis for his or her legal claims at deposition is not the relevant inquiry.
Mm-hmm.
Lively and Reynolds mistakenly attempt to draw some importance to the fact that Sarowitz and Abel were unable to answer questions at their depositions concerning the allegations in the complaint without relying on insights from their lawyer. But a party is not expected to answer questions at his or her deposition about the factual basis for his or her legal claims, particularly when, as here, the allegations are based upon counsel's investigation and later discovery rather than the party's personal knowledge, as
Just
noted.
A note here, the little bit of her deposition that has come out, as exhibits or whatever, she relies upon saying I can't answer that because that's like something I learned from my lawyer. So of course, and of course here she's like, this is a terrible. Why would you do that? You know what I mean?
Yeah.
So.
No. As noted by Lively regarding her own inability to articulate the basis of her claims. Wow, it's like you read this of that deposition. It makes no sense to suggest that facts in a party's personal knowledge, as opposed to facts developed from the public record, from the investigations of others, and through discovery, would be particularly relevant to never mind dispositive of the nature of the challenged conduct. Moreover, a party's inability to articulate the factual basis for his claim at deposition is not even sufficient to warrant summary judgment. Fourth, the Sarowitz and Abel testimony ignores other evidence uncovered in discovery, which demonstrates that, in fact, there was ample evidence to support the defamation claim against Reynolds. The document produced by Lively reflects Reynolds redacted. A bunch of stuff is redacted. These documents show, among other things, a bunch of stuff. So the evidence also demonstrates that Reynolds overtly attempted to interfere with Baldoni and Wayfair's relationship with WME.
Right.
Reynolds on the Wayfair parties, something. All right. So for the foregoing reasons, the Wayfair parties respectfully request that the court strike Lively's letter and accompanying declaration and deny the related motion to seal as moot. If the court does grant leave to Lively and Reynolds, the Wayfair parties respectfully request that the court grant them leave to file a fulsome substantive response to the letter within 2 weeks. Well, I would agree with the assertion that it was a procedurally deficient way to go about supplementing a Rule 11 motion months after the fact. And the fact that they waited so long after the depositions to get it in at on the eve of the weekend after the MSJ comes out to try to control the news cycle. Yeah, that's not a good look.
Right.
But, Judge Liman is going to do what he does with it. If you ask me what I think he's going to do, he's probably going to invite the Wayfair parties to brief in opposition and then rule on it later, like he's been doing this entire case.
Well, he's obviously just trying to feed content creators. So
totally. Exactly what he's doing.
Oh my gosh.
Anyway,
these last few letters by her with the sanctions motions people have been pointing out like different Karen-like scenes in movies, and one of them is from White Chicks. You ever watch that movie White Chicks? You have to have seen it.
Like 20 years ago, man.
Okay. Well, somebody points out the quote, "Dear Mr. Royal Hampton," and then she's like writing to the manager at the front desk. Yeah, that is kind of what it reminds me of. So.
I do not remember that scene in the movie, but I'll go with it.
Random question not related to documents, right? So there's this headline going around recently that Justin Baldoni missed the deadline for his appeal, which was not true. The clock hasn't started until the judge rules on the issue of fees. And so, that was going around, and then they got called out. TMZ especially got called out by Brian Friedman for like saying things that were absolutely not true. And then when I'm looking at the redactions in this letter, I'm wondering, like, if they're going to appeal, does anything that happened in discovery matter for like an appeal?
I mean,
In this case, I guess for their dismissed case, I don't know these things. So
could they appeal based on a discovery deficiency on a dismissed case?
So, like, if something popped up in discovery that would help them to prove that there
like
was
after the fact.
Yes, yeah.
Yeah,
Is that
it would
possible? Like,
I mean, I don't know if that would become an appellate issue as opposed to like just a way to reintroduce the litigation. Maybe it becomes
Okay.
a basis for appeal, but it'd have to be something that they could not have plausibly discovered at the time that it was supposed to be discovered.
okay.
Like, for example, somebody committed extrinsic fraud and we didn't know that they did that. And we figured out that they spoliated all kinds of evidence and destroyed things that
Yeah.
made it impossible to fairly litigate and therefore denied somebody's rights to due process by fairly litigating the thing and cause the thing to get dismissed. Yeah, there could be grounds for appeal, but they'd have to show something like that. It'd have to be something that was not discoverable at the time.
Gotcha.
And that they ran across after the fact.
Okay. Yeah. Okay.
So with that, I think we're gonna wrap up because I'm tired now. And
Yeah, it's
like
about 1:30 here, so
yeah, it's 10:30 and I'm
Yeah.
I don't know, man. It's past my bedtime.
Fair enough.
And my voice is about to go.
Oh no.
And my wife wants me to be done. So
Yeah.
that's what's gonna happen.
Yeah, that's fine.
Anyway, oh wait, you have a Aquanetta. What's up, young lady? Thank you so much for the $10 super stickers. Good to see you back here in the chat. For the rest of you folks, I love you all, and we will see you guys next time. Lauren, thanks so much for joining me and catching me up on this case.
No, happy to have you back. So
we will be in touch. All right, everybody. You guys take care. Have a good night. Bye-bye.
Thanks.